Good evening, Professor. My name is Laachi Mali, and my partner's name is Gurmanjot Singh, and today we are here to present the Tort video. So, according to me, the specific tort committed here is negligence, as the car driver is recklessly driving the car, which caused the harm to the cyclist, and also I feel that cyclist is partially responsible for the harm occurred.
If we talk about the fault, as we can clearly see in the video, the cyclist is crossing the road on the red light and that too outside a pedestrian crossing. On the other hand, the car driver is also turning his car without slowing down or looking at all the sides to proceed with caution. So both the parties here are at fault. If we talk about the liability, tort law clearly describes that a person who causes the harm is the tortfeasor, and in the video, it can be clearly seen that the car driver is at primary liability here, but he could be partially liable due to contributory negligence of the cyclist.
The four-part legal test a plaintiff must prove in order to sue the defendant is duty of care, standard of care, breach, causation, and remoteness.
If we talk about the first, that the duty of care, all the car drivers in Canada have a primary duty towards the pedestrians and cyclists to proceed with caution, even when the pedestrians or cyclists are not properly crossing the road. So the car driver owes the duty of care to the cyclist. If you come on to the second one, the standard of care, in this situation, a reasonable car driver would have slowed down and looked in each direction while turning his car as required by the driving rules in Canada. But it can be clearly seen in the video that the car driver did not live up to this reasonable standard of care.
Coming to the causation, the plaintiff can prove that the harm would not have occurred if the defendant have drove and followed the car rules and regulation which are by law. And talking about the fourth part, as in the last part of the legal test, plaintiff can prove that the car driver is liable for the full amount of harm caused, even though if it was worse otherwise. So here it applies the thin skull rule.
Uh, as we discussed in the four-part legal test, the car driver did not slow down his car, and neither did he look in all the directions before turning the car, which a reasonable car driver would have surely done because of the road rules in Canada. So therefore, the defendant has surely failed to meet the standard of care in this situation.
So, in my opinion, I think that plaintiff wins the lawsuit as in many ways defendant drove over the cyclist and by law, pedestrian must be given the right of way.
If we talk about the damages that the plaintiff could sue for, is the first one will be pecuniary damages because it can be clearly seen in the video that plaintiff here has suffered a lot of physical damage due to which he could have suffered a lot of future income and out of the pocket expenses, and therefore he could sue the defendant for these damages.
And talking about the non pecuniary damages, according to the video, it is visible that the plaintiff would have lost life. Loss of life enjoyment as soon as the car crashed. We can see in the video that the cycle and the cyclist was very unconscious.
If we talk about the mitigation process, the plaintiff could have mitigated his damages by stopping his bike or moving it in another direction when he saw that the car was not stopping and was coming towards him in very high speed. And at the first place, also, he should not have crossed the road on a red light and that too outside a pedestrian crossing.
So, talking about the contributory negligence in this particular video, in accordance to this case, I strongly believe that in the matter of this accident, contributory negligence is applied as the car driver, the defendant, in his defense, can state that plaintiff, as in the cyclist, is at least partially responsible for the harm occurred as he was riding the bicycle through the red light. First was at that point. Outside that, he was driving on the designated track. He was not driving on the designated track. In order to that, defendant could not reduce his damages as plaintiff is somewhat responsible for the cause. Thank you.
Thank you.